We're here at ABI's Views from the Bench at Georgetown University Law Center, talking with Michael Bernstein. Just moderated a panel on director and officer liability in bankruptcy. Michael is the National Bankruptcy Practice Chair at Arnold and Porter K. Scholler in the District of Columbia. So we're talking about duties before and during and maybe and after bankruptcy, giving lots of folks a headache, even including the judges who were serving on your panel with the various hypothetical liability that can be spun out.
I have a way of giving people headaches. It's a problem.
Everybody agrees that there is a duty, a fiduciary duty, but it seems like the parameters of the duty can differ among the various stakeholders. If you're a secured creditor or you're an out-of-the-money creditor, you're an employee, or retiree, your equity, all of those people may have a different view of what the duty is. So if you're in a failed company situation and you're a director, it seems like you're fraught with danger here, right? That you can be sued for any and every decision you make. So if you're advising directors and officers in this failed company situation, what's the advice? What do you tell them about how to insulate against acts that have already occurred?
So the situation, Sam, that you refer to is, I think, inevitable, and people wish it didn't exist, but inevitably, in a complex capital structure at least, where you sit is a function of where you stand, or maybe it's the other way around, that the senior lenders want to take as little risk as possible, and as you go down the capital structure, people want to take more and more risk, and yet the director is told that her duty is to maximize the value of the estate. Different stakeholders have different views as to how the director should go about doing that. I think the best thing for the director to do is keep in mind the two fundamental duties that a director has. One is the duty of care, and one is the duty of loyalty. With respect to the duty of loyalty, you have to consider the company's interests above your own interests or any other entity with which you're affiliated. You have to wear your director hat at all times. With respect to the duty of care, the director should be well informed and get professional, expert, appropriate advice from people who themselves are disinterested, who are loyal only to the company. And I think that's the best way that the director can insulate herself from breach of duty claims, because inevitably some stakeholder is going to be unhappy, dissatisfied with the decision that the director makes. And if the answer is, I was absolutely loyal, I was considering only the company's interest, I was seeking to maximize the value of the estate without regard to where the value breaks, and in seeking to do so, I got professional, expert advice from independent, qualified people who themselves are loyal only to the estate. I think that's the best way to insulate yourself from liability.
If you do all that, don't you still have a risk that that good faith decision and that good faith sound process is going to be second guessed in some court, someplace, and you're still going to be at risk of liability?
Yeah, I mean, not a question, right? Somebody said lawyers get paid to sue people. That's an oversimplification. But the reality is that there are a lot of cases where the only way some stakeholder, be it a creditors committee or an equity committee or whatnot, is going to generate value for its constituency is to bring a lawsuit. And because directors typically have D&O policies, it's the low-hanging fruit. So sure. So what you want to do is you want to make sure that the plan gives you the maximum permissible release and exculpation if your company reorganizes in Chapter 11, and then you want to make sure that the company has adequate D&O insurance, including Side A coverage available to the directors, and that the company purchases a tail insurance so that if claims are made after the reporting period, that you're going to have adequate insurance for those claims. There's nothing a director can do to create certainty that claims won't be brought, but you can protect yourself.
Wow. Thanks very much for the panel today. It was very interesting, if not headache-inducing.
It's always fun to give people headaches.
Thanks, Michael.
Thanks.